Hi everybody, welcome to the Supreme Court Show. In this video I'm going to be covering the arguments that will take place before the Supreme Court on October 2nd. And if you're watching this after October 2nd, I'll have a link to the oral arguments themselves below. And then once the opinion comes out, I'll also have a video about that, so that will be linked in the description below as well. So I'm just going to be briefly covering the basic arguments from both sides, and then if you're interested, you can kind of dig in further. I'll have the briefs from both sides also linked below in the description. So just some context, the defendant was caught selling drugs and sentenced to over 13 years in prison, and the issue is the interpretation of a statute. The defendant is arguing that he's entitled to safety valve relief, where the court will have discretion to lower his sentence below the mandatory minimum guidelines, and the United States is arguing the opposite, that under this statute the defendant does not have safety valve relief. So it's kind of a tricky argument because it's about interpreting statutes, and that can kind of be ambiguous and confusing. So here's the statute. Notwithstanding any other provision of law, in the case of an offense under this statute or other federal drug laws, the court shall impose a sentence without regard to any statutory minimum sentence if the court finds at sentencing, after the government has been afforded the opportunity to make a recommendation, that 1, the defendant does not have A, B, and C. I'm not going to read the whole thing. You can pause the video if you would like. But just to quickly stay on this slide before moving on, they're arguing how, does each of these conditions have to be met for the safety valve relief to occur, or does just one of them have to be met? So does A, B, and C all have to occur, or A, B, or C? The U.S. is arguing that the prefatory phrase of the statute, the prefatory phrase being the defendant does not have, it modifies each of the subsections A, B, and C severally. The second argument is a common sense reading argument, and then the third argument is refuting what the defendants are saying, that the U.S. is basically just changing and into or. So to get into more depth here, the prefatory phrase modifies each of the subparagraphs severally, and treating the subparagraph as a unit would, as the defendants would like, would make the subparagraph would make the statute superfluous. So looking here, the U.S. is basically saying you can read it this in two ways. You can read it firstly as the defendant does not have A, B, and C, or you can read it in the second way, which is what they're advocating, that the defendant does not have A, the defendant does not have B, and the defendant does not have C. And in that case, it sort of turns and into or. So it could be A, B, or C. That's my understanding. The second argument is a common sense reading, that each of these, A, B, or C on their own could be enough to deny a defendant from extraordinary relief. So for example, why would somebody who has 4 criminal history points get off if they don't have get off from this relief if they don't have also a 2-point violent offense? So they're saying any one of these on their own is enough to deny the relief. And the third argument is just that they're not saying and means or, that you have to look at the prefatory phrase in combination with the rest of it. So you can't just look at A, B, and C and use that and that's highlighted there. You have to also take into account subsection 1 and apply it to A, B, and C. The petitioner's arguments are that a strict reading of and means and. You cannot you can't change it, and it's very obvious. That the government's distributive interpretation does not work in the context of the rest of the statute, and they're also making an argument with the rule of lenity. So just use and in the ordinary sense of the word. That's pretty self-explanatory, just looking back at the statute here. And means that A, B, and C must all be met at the same time, is what they're arguing. That you don't look at the prefatory phrase at all, or at least not in the way that the U.S. is arguing. The second argument is that the distributive reading is impermissible. that the use of the word and must be interpreted consistently. And so if you're going to basically, they're saying you're basically turning an and construing it in a way that it's an or in this section, but if there's an other section, somewhere else in the statute where and is used as an and, then that it just doesn't make sense. That's the best way I can explain that argument. And then the rule of lenity is that an ambiguous criminal statute should be resolved in favor of the less severe punishment. Therefore, in this case, if it's confusing, then you need to construe it in the light most favorable to the defendant, which would require having to have A, B, and C all fulfilled at the same time. So yeah, that's the very brief overview of the arguments. I've tried to explain them as best I can. The briefs will be linked in the description below if you really want to dig into this, if you just love to interpret statutes in your free time. But the oral arguments are set for October 2nd. I will stream them and post them on my channel, but they'll also be linked below. And yeah, thanks for stopping by the channel and have a great day.